The certified letter arrived on a Tuesday morning in September, and I knew it was trouble the moment I saw the return address from the Willow Creek Homeowners Association in Phoenix, Arizona. My name is Marcus Nolan, and I had been living peacefully in my modest 3-bedroom ranch house for the past 5 years without a single problem. That was about to change in ways I could not have imagined. I tore open the envelope and pulled out the official-looking document inside. The header read "Notice of Fine" in bold letters, and my stomach dropped as I scanned the contents. According to this letter, I was being fined $1,500 for maintaining an unauthorized structure on my property. The unauthorized structure in question: a small wooden pergola I had built in my backyard 3 months earlier to provide shade over my patio furniture. The letter was signed by Patricia Hendricks, the HOA president, a woman in her late 40s with perfectly styled blonde hair who seemed to take personal offense at anything that deviated even slightly from her vision of suburban perfection. I had encountered her exactly twice since moving in, both times at mandatory HOA meetings where she spent 2 hours lecturing everyone about proper mailbox maintenance and acceptable paint colors. I read through the letter again, my confusion growing with each sentence. According to our HOA bylaws, which I had actually bothered to read when I purchased the house, any fine over $500 required a formal vote by the entire board of directors. The letter made no mention of such a vote. It simply stated that I had 30 days to pay the fine or face additional penalties, including potential legal action and liens against my property. My hands shook slightly as I pulled out my phone and dialed the number listed on the letterhead. A cheerful voice answered on the 3rd ring. "Willow Creek HOA, this is Brenda speaking. How may I help you?" "Hi, Brenda. This is Marcus Nolan from 4287 Desert Rose Lane. I just received a fine notice for $1,500, and I have some questions about it." There was a pause, and I heard the clicking of computer keys. "Ah, yes, Mr. Nolan. The fine for the unauthorized pergola. What questions did you have?" "Well, first of all, I checked the architectural guidelines before building it, and nowhere does it say that a pergola requires pre-approval. Second, the fine amount seems excessive. And third, I don't see any record of a board vote, which is required for fines over $500 according to Article 7, Section 3 of our bylaws." Another pause. "Hold on, let me transfer you to Mrs. Hendricks." Before I could protest, the line clicked and generic hold music filled my ear. I waited for nearly 10 minutes, my irritation growing with each passing moment. Finally, the music cut off, and Patricia Hendricks' crisp voice came through the speaker. "Mr. Nolan, I understand you have concerns about your fine." "Mrs. Hendricks, yes. I have several concerns, actually. Starting with the fact that I don't believe I violated any rules, and ending with the fact that this fine appears to have been issued without proper board approval." Her tone turned icy. "Mr. Nolan, I am the president of this HOA, and I have the authority to issue fines as I see fit when violations occur. Your pergola is an eyesore and was not approved by the Architectural Review Committee." "I checked the guidelines," I said, keeping my voice level despite my rising anger. "Pergolas are not listed as structures requiring approval, and regardless of whether you think it is an eyesore, you do not have the authority to unilaterally issue fines over $500. The bylaws are very clear on this point. Mr. Nolan, I suggest you pay this fine promptly. The longer you delay, the more additional fees will accumulate. Good day." The line went dead before I could respond. I sat in my kitchen, staring at my phone in disbelief. I had always been the type to avoid confrontation, to go along to get along. But something about Patricia's dismissive attitude and complete disregard for the rules she was supposed to be enforcing ignited something in me. I was not going to pay this fine, not without a fight. That evening, I drove to the house of Tom Chen, one of my neighbors 3 doors down. Tom was a lawyer, though his specialty was contract law rather than HOA disputes. Still, he might have some insight into my situation. His wife answered the door and welcomed me inside, calling for Tom, who appeared from his home office carrying a mug of coffee. "Marcus, good to see you. What brings you by?" I explained the situation, showing him the fine notice and walking him through my research on the bylaws. Tom read through everything carefully, his expression growing more serious as he went. "This is interesting," he finally said. "You are absolutely right about the board vote requirement. It is not even a gray area. The bylaws explicitly state that any fine exceeding $500 must be approved by a majority vote of the board, and the homeowner must be given an opportunity to present their case before the vote takes place. So, what do I do? Write a formal letter to the board disputing the fine. Cite the specific bylaw provision and request documentation of the board vote. Keep everything in writing from this point forward. If they cannot provide proof of a proper vote, the fine is invalid." I thanked Tom and went home to draft my letter. I spent 2 hours crafting it, making sure every word was professional and every argument was backed by specific references to the governing documents. I sent it via certified mail the next morning, requiring a signature upon delivery. A week passed with no response. Then another week. On the 19th day after I sent my letter, I received another certified mailing from the HOA. This time, the fine had increased to $3,000, with the letter citing continued violation and failure to comply with previous notice. There was still no mention of a board vote. I immediately called Tom again. This time, his advice was more direct. "They are doubling down. This is actually good for you in a weird way because they are creating a paper trail of their own misconduct. But you need to file a formal complaint now. Do not wait for them to escalate this further. File a complaint where you have 2 options. You can request binding arbitration, which is typically faster and cheaper, or you can file suit in district court. Given the amounts involved and the principle at stake, I would recommend court. And Marcus, I think you should look into whether this is a pattern. If Patricia has been issuing fines without board approval for other homeowners, this could be much bigger than just your case." That suggestion lodged in my brain and would not let go. That weekend, I spent Saturday afternoon walking through the neighborhood, knocking on doors and talking to my neighbors. What I discovered was shocking. At 4156 Desert Rose Lane, Sarah Martinez told me she had been fined $1,200 8 months earlier for painting her front door a shade of red that Patricia deemed too bright. Sarah had paid the fine rather than fight it, even though she thought it was unfair. At 4198 Desert Rose Lane, elderly Robert Kim showed me a fine notice for $2,000 that he received for allowing his grass to exceed 4 inches in height during a particularly hot summer, when water restrictions made it difficult to maintain a perfect lawn. He had also paid, worried that fighting would result in losing his home. At 4312 Desert Rose Lane, Jennifer Wu had been fined $800 for parking her work van in her driveway overnight. She provided essential HVAC repair services and needed the van for her business, but Patricia had declared it commercial vehicle presence and fined her without any board discussion. By the end of the day, I had documented 11 different cases of substantial fines issued over the past 3 years, none of which appeared to have gone through the proper board approval process. The total amount collected in improper fines was over $18,000. Monday morning, I contacted a real estate attorney named Michael Foster, whose office was in downtown Phoenix. I explained the situation and provided him with all my documentation, including the stories from my neighbors. Michael listened carefully, asking pointed questions and taking detailed notes. "Mr. Nolan, this is more serious than a simple dispute over a single fine. If what you are telling me is accurate, and I have no reason to doubt you, this represents a systematic violation of fiduciary duty by the HOA president. The board members, if they were aware of this and did nothing, could also be liable. I think we have grounds for a significant legal action." "What kind of legal action?" "We would file a complaint in Maricopa County Superior Court seeking several forms of relief. First, we would ask the court to invalidate your fines as being issued without proper authority. Second, we would seek an injunction preventing the HOA from issuing any further fines without following proper procedures. Third, and this is the big one, we would ask the court to review all fines issued over the past 3 years and invalidate any that were improperly authorized. If other homeowners want to join as plaintiffs, we could make this a class action." My head spun with the implications. "How much would this cost?" "I will be honest with you. This kind of litigation is not cheap. But given the strength of your case and the potential for recovering fees from the HOA if we prevail, I would be willing to take this on a partial contingency basis. You pay a reduced hourly rate up front, and if we win, my full fees plus costs come out of the judgment or settlement." I thought about it for all of 30 seconds. "Let's do it." The complaint was filed on October 15th. In it, we laid out the entire pattern of unauthorized fines, citing chapter and verse from the HOA's own governing documents. We named Patricia Hendricks individually, as well as the HOA as an entity. We requested that the court invalidate all improperly issued fines and order the HOA to return money that had been collected. 3 days after we filed, I received a phone call from a number I did not recognize. I answered cautiously. "Mr. Nolan, this is Gregory Walsh. I am on the HOA board of directors, and I just learned about the lawsuit you filed. I need to speak with you urgently." "I am listening." I had no idea Patricia was issuing these fines without board approval. None of us did. She told us at board meetings that she was handling various violations, but she never brought any of these fines to us for a vote. I pulled the meeting minutes for the past 3 years, and there is not a single recorded vote on any fine exceeding $500. This was an interesting development. "Mr. Walsh, are you telling me that the entire board was unaware of what Patricia was doing?" "That is exactly what I am telling you. There are 5 of us on the board, including Patricia. The rest of us are just regular homeowners who volunteered because nobody else would. Patricia handles most of the day-to-day operations, and we assumed she was following proper procedures. This is a mess, Mr. Nolan. A complete mess. Why are you calling me?" "Because I want to fix this. I have called an emergency board meeting for tomorrow night. I am going to move for Patricia's immediate removal as president, and I am going to recommend that we settle your lawsuit on terms that make this right. Will you at least consider a settlement if we make a reasonable offer?" I told him I would discuss it with my attorney, and we ended the call. When I relayed the conversation to Michael, he was cautiously optimistic. This could be good. If the board removes Patricia and acknowledges wrongdoing, we might be able to reach a settlement that accomplishes your goals without months of litigation. But we need to be careful. They might just be trying to minimize their exposure. The emergency board meeting was held at the community center on October 18th at 7 in the evening. I attended along with Michael and about 30 other homeowners who had heard about the lawsuit and wanted to see what would happen. The tension in the room was thick enough to cut with a knife. Patricia sat at the head table with the 4 other board members. She looked composed, but I could see the tightness around her eyes and mouth. Gregory Walsh called the meeting to order and immediately addressed the elephant in the room. We are here tonight because serious allegations have been raised about improper procedures in the issuance of fines by our HOA. I have conducted a preliminary review of our records, and I am deeply troubled by what I found. I am going to make a motion shortly, but first I want to give Mrs. Hendricks an opportunity to address these concerns. Patricia stood up, her expression defiant. What we have here is a disgruntled homeowner who does not want to follow the rules. I have been president of this HOA for 3 years, and in that time, I have worked tirelessly to maintain our property values and ensure that our neighborhood remains beautiful. If Mr. Nolan and others do not like the fines they received, perhaps they should consider not violating the rules in the first place. Mrs. Hendricks, Gregory said, his voice hardening, that is not what I asked. Did you or did you not issue fines exceeding $500 without bringing them to the board for a vote as required by our bylaws? I issued fines as appropriate based on violations I observed. As president, I have the authority to enforce our rules. That is not an answer to my question. Patricia's face flushed red. I do not appreciate your tone, Gregory. I am the president of this association, and I expect to be treated with respect. You were the president, Gregory said quietly. I move for your immediate removal from that position based on gross violation of your fiduciary duties and systematic disregard for our governing documents. The other 3 board members voted immediately. The motion passed 4-1, with only Patricia voting against. She stood there for a moment, her face pale, before gathering her things and walking out of the room without another word. The meeting continued for another hour. Gregory was elected as the new president, and the board voted unanimously to authorize settlement negotiations with me and any other homeowners who had been improperly fined. They also voted to hire an independent auditor to review all financial transactions for the past 3 years to ensure there were no other irregularities. That last decision would prove to be consequential in ways none of us expected. The settlement negotiations began the following week. Gregory and the board's attorney, a pleasant woman named Rebecca Stone, met with Michael and me at Michael's office. They came prepared with a proposal. We acknowledge that the fines issued to Mr. Nolan were improper and should be invalidated, Rebecca began. We are prepared to provide written confirmation that he owes nothing and never did. We will also revise our internal procedures to ensure that all future fines follow proper authorization protocols. In exchange, we ask that Mr. Nolan dismiss his lawsuit with prejudice. What about the other homeowners who were fined improperly? I asked. Gregory spoke up. We are prepared to offer the same relief to any homeowner who can demonstrate they were fined in excess of $500 without a board vote. We will invalidate those fines as well. And what about the homeowners who already paid their fines? Michael asked. There was a long pause. Rebecca and Gregory exchanged glances. Finally, Rebecca said, "That is more complicated. The funds have been spent on HOA operations. We do not have the liquid assets to refund $18,000 in payments." "Then you need to find a way," Michael said firmly, "because those payments were extracted under false pretenses. The fines were never valid to begin with. If people paid them, they are entitled to refunds." The negotiations continued over several more meetings. The board was genuinely trying to do the right thing, but they were constrained by financial reality. The HOA's operating budget was tight, and an unexpected $18,000 expense would require either a special assessment levied against all homeowners or a significant reduction in services and maintenance. While these discussions were ongoing, the independent auditor completed her review. What she found sent shockwaves through the community. Patricia had not just been issuing improper fines. She had also been systematically diverting HOA funds to her own use. Over the course of 3 years, she had embezzled nearly $43,000 through a variety of schemes. She created fake invoices from non-existent vendors for maintenance work that was never performed. She approved reimbursements to herself for HOA expenses that were actually personal purchases. She even wrote herself checks from the HOA account on several occasions, disguising them as legitimate payments in the ledger. Gregory called me the day the audit report was finalized. His voice shook with anger and disbelief. "Marcus, I need you to come to an emergency meeting tonight. We are contacting the police. Patricia has been stealing from us on a massive scale." That evening, I sat in the community center with about 50 other homeowners as Gregory presented the audit findings. The room erupted in outrage. People who had paid improper fines were furious to learn that their money had likely gone straight into Patricia's pocket. Those who had been faithfully paying their HOA dues were appalled to discover that tens of thousands of dollars had been stolen. 2 detectives from the Phoenix Police Department arrived halfway through the meeting. They took custody of the audit report and all supporting documentation. They asked Gregory and the other board members detailed questions about HOA operations and Patricia's access to the accounts. They took statements from several homeowners, including me. "We will be opening a formal investigation into this matter," Detective Sarah Whitmore told the assembled crowd. "Embezzlement of this magnitude is a serious felony. If the evidence supports criminal charges, we will forward the case to the Maricopa County Attorney's Office for prosecution." The investigation moved quickly. Detectives executed a search warrant on Patricia's home and seized financial records, computers, and documents. They interviewed vendors and contractors who had allegedly been paid for work. Many of those vendors did not exist at all, the checks having been deposited into accounts Patricia controlled. Within 2 weeks, Patricia Hendricks was arrested and charged with 9 counts of theft, 2 counts of fraudulent schemes and artifices, and 3 counts of forgery. The total amount she was alleged to have stolen came to $42,873. She was released on bond, but ordered to have no contact with any HOA business or board members. The criminal case complicated our civil lawsuit. Michael advised me that we should proceed with the settlement for the improper fines, but preserve our ability to seek additional damages related to the embezzlement. The board agreed to those terms, and we signed a settlement agreement in mid-November. Under the settlement, my fines were invalidated, and the HOA acknowledged in writing that I had never violated any rules. The pergola could stay. All other homeowners who had been issued improper fines received the same relief. The board set up a restitution fund and worked out a payment plan to refund everyone who had paid invalid fines. The money would come from HOA reserves and, if necessary, from recovery of funds through the criminal case against Patricia. The board also implemented comprehensive reforms. All financial decisions now required approval from multiple board members. The HOA hired a professional management company to handle day-to-day operations with proper oversight. Fines could only be issued after a formal hearing process with proper notice and board approval. The Architectural Review Committee was restructured to include more community input. As for my specific situation, I documented everything that happened and submitted a detailed affidavit as part of my settlement. The agreement specified that the court would retain jurisdiction to enforce its terms and to address any disputes about implementation. On December 3rd, Judge Amanda Morrison of the Maricopa County Superior Court issued a comprehensive order. The order invalidated not just my fines, but all fines issued by the Willow Creek HOA over the previous 3 years that exceeded $500 and lacked proper board authorization. The court found that 16 different homeowners had been improperly fined, with total invalid fines exceeding $21,000. The court ordered the HOA to provide full restitution to anyone who had paid these fines and permanently enjoined the association from issuing any future fines without following proper procedures. Judge Morrison's written opinion was scathing in its criticism of Patricia's conduct. She wrote that the HOA president's systematic disregard for governing documents and fiduciary duties represented a betrayal of the trust placed in her by the community she was supposed to serve. The judge noted that HOA boards exist to serve homeowners, not to exercise arbitrary authority, and that proper procedures exist to protect both the association and individual homeowners from abuse. The criminal case against Patricia moved through the system over the following months. I testified at her preliminary hearing, describing how I first discovered the improper fines and what led me to investigate further. Other homeowners testified about their experiences. The prosecutor presented the audit findings and bank records, showing how Patricia had systematically looted the HOA accounts. Patricia's attorney attempted to negotiate a plea deal, but the county attorney's office was not inclined to be lenient given the scope and duration of her crimes. The case went to trial in April of the following year. I attended several days of testimony, watching as the prosecution methodically built its case. The jury deliberated for less than 4 hours before returning guilty verdicts on all counts. At sentencing 2 months later, Judge Richard Torres sentenced Patricia to 6 years in state prison and ordered her to pay full restitution of $42,873 plus interest. She was also ordered to pay an additional $18,000 to cover the costs of the audit and the HOA's legal expenses related to remedying her misconduct. "Miss Hendricks," Judge Torres said at sentencing, "you were entrusted with a position of responsibility in your community. Rather than honoring that trust, you abused your authority to enrich yourself at the expense of your neighbors. The amount you stole was substantial, but the real damage goes beyond dollars and cents. You undermined the faith that people place in community institutions. You made people afraid to stand up for their rights because they thought you had unchecked power over them. That is perhaps the most serious harm of all." Patricia showed no emotion as she was led away in handcuffs. The restitution process took time, but eventually everyone who had been improperly fined received their money back. The HOA was able to recover about half of what Patricia stole through seizure of her assets and liquidation of investments she had made with the stolen funds. The remainder was covered through HOA reserves and a modest special assessment spread over 2 years. As for me, I emerged from the experience with a new appreciation for the importance of standing up when something is wrong, even when it would be easier to just go along. My little pergola still stands in my backyard, providing shade on hot Phoenix afternoons. But every time I sit under it, I think about what it represented: a refusal to be bullied by someone who thought their position gave them unlimited authority. The Willow Creek HOA is now run very differently than it was under Patricia's reign. The new board holds regular open meetings where homeowners can voice concerns. Decisions are made transparently, with proper votes and documented minutes. The professional management company has brought competence and accountability to operations. Most importantly, there is a culture of respecting both the rules and the rights of homeowners. My neighbors Sarah, Robert, and Jennifer all got their money back. Sarah repainted her front door an even brighter shade of red, and nobody said a word. Robert maintains his lawn according to sensible standards rather than Patricia's obsessive requirements. Jennifer parks her work van in her driveway every night without fear of harassment. About 6 months after Patricia's sentencing, I was working in my front yard when Gregory Walsh walked up my driveway. He had continued as HOA president and had done an excellent job of rebuilding trust in the organization. "Marcus, I wanted to thank you again for what you did," he said. "A lot of people would have just paid the fine and moved on. You could have fought just for yourself. Instead, you exposed a problem that was hurting the entire community." "I just did what anyone should do when they see something wrong," I replied. "No," Gregory said, shaking his head. "Most people do not do that. Most people avoid conflict and assume someone else will handle it. You stood up, and because you did, we discovered that Patricia was not just abusing her authority but actively stealing from all of us. You saved this community." I did not feel like a hero. I felt like someone who had simply refused to accept being treated unfairly. But I appreciated Gregory's words nonetheless. That evening, I fired up my grill under the pergola and invited Tom Chen and his wife over for dinner. We sat in the backyard as the sun set over the Arizona desert, painting the sky in brilliant shades of orange and purple. "You know what the best part of all this is?" Tom said, taking a sip of his beer. "You proved that the system actually works when people use it properly. You followed the rules, you documented everything, you went through proper legal channels, and you got justice. That is not something everyone can say." He was right. The system had worked, though it required persistence and a willingness to fight for what was right. The court had done exactly what it was supposed to do: enforce the rules that everyone had agreed to follow and protect individuals from abuse of authority. As I sat there with friends in the cool evening air, I thought about the journey from that first certified letter to this moment. It had been stressful and expensive and time-consuming. There were many nights when I questioned whether it was worth the effort. But seeing how the community had been transformed, how people now had confidence that their HOA would treat them fairly, I knew it had been worth every penny and every hour. The legal precedent established by our case also had broader implications. Other HOAs in Arizona and beyond took notice when word spread about what happened in Willow Creek. HOA attorneys began advising their clients to review their fine issuance procedures and ensure they were following their own governing documents. Several other homeowners in different communities contacted Michael Foster's firm after discovering similar problems in their associations. The case became a teaching example in HOA management courses about the importance of proper procedures and accountability. For me personally, the experience changed how I approached community involvement. I ran for the HOA board in the next election and won a seat. I served 2 terms, working with Gregory and others to continue improving how the association functioned. We updated the architectural guidelines to be clearer and more reasonable. We established a financial oversight committee that reviewed all expenditures monthly. We created an informal mediation process for disputes so that problems could be resolved without immediately jumping to fines or legal action. The pergola that started it all became something of a neighborhood landmark. When new residents moved in, They often heard the story of how a simple backyard structure led to the exposure of systematic fraud and abuse. Some found it amusing, others found it inspiring. I just found it a reminder that seemingly small acts of resistance can have unexpectedly large consequences. 3 years after the whole ordeal began, I was sitting under that pergola on a Saturday morning when I saw a young couple walking slowly down the street, clearly looking at houses. They stopped in front of my yard, and the woman pointed at something. I walked over to see what had caught their attention. "Can I help you folks?" I asked. "Oh, hi," the man said. "We are thinking about buying in this neighborhood. We were just admiring your pergola. We have been looking at HOA rules and they can be pretty restrictive." It is nice to see someone was able to add something like this. I smiled. "There is actually quite a story behind this pergola. Have you got a few minutes?" They did, and I told them an abbreviated version of everything that had happened. Their eyes grew wider as the tale unfolded. "Wow," the woman said when I finished. "So the HOA here is actually reasonable now." "Very much so," I assured them. "We learned some hard lessons, but we came out stronger for it. If you do buy here, you will find it is a good community with sensible rules and fair enforcement." They thanked me for the information and continued their walk. I returned to my pergola, poured myself another cup of coffee, and picked up the book I had been reading. A few weeks later, I saw a moving truck in front of a house 2 blocks over. That evening, the same couple I had spoken with knocked on my door. "We wanted to let you know we bought a house here," the man said. "Your story actually made us more comfortable with the idea of an HOA, knowing that the system can work when people hold leadership accountable." "Welcome to the neighborhood," I said, shaking both their hands. "If you ever have any questions or concerns, do not hesitate to reach out." As they walked away, I reflected on how much had changed since that September morning when I received the first fine notice. What started as a personal dispute over a backyard structure had evolved into a community-wide reckoning with abuse of power. The legal victory had been important, but the real triumph was in creating a culture where people felt empowered to question authority and demand accountability. The court's invalidation of 3 years of improperly issued fines sent a clear message that HOA boards must operate within the constraints of their own governing documents. Patricia's criminal conviction and prison sentence demonstrated that embezzling from an HOA was not a victimless crime or a minor matter, but serious fraud that would be prosecuted vigorously. For the homeowners who had been fined improperly, getting their money back was important. But more than that, they got validation that they had been wronged and that the system recognized and corrected that wrong. For elderly Robert Kim, who had been terrified of losing his home over a lawn height violation, the relief was profound. For Jennifer Wu, who had paid $800 she could not afford for parking her work vehicle in her own driveway, the refund meant she could finally replace her aging water heater. The reforms implemented by the new board ensured that future residents would be protected from similar abuses. The requirement for multiple approvals on financial matters meant no single person could again raid the HOA coffers. The formal hearing process for fines meant homeowners would always have an opportunity to be heard before being penalized. The professional management company provided expertise and continuity that prevented important procedures from being ignored or forgotten. On a personal level, I gained confidence in my own judgment and willingness to stand up for principle, even when facing intimidating opposition. Patricia had counted on people being too afraid or too apathetic to challenge her. For years, that calculation had been correct. But eventually she encountered someone who refused to back down, and her entire house of cards collapsed. I also gained a deeper understanding of how important it is for ordinary citizens to pay attention to the institutions that govern their daily lives. HOAs control many aspects of homeownership for millions of Americans. When those organizations are run properly, they can genuinely enhance property values and quality of life. When they are run poorly or corruptly, they can make people miserable in their own homes. The only way to ensure good governance is for residents to stay engaged, to read the governing documents, to attend meetings, and to speak up when something seems wrong. The legal bills from the case were substantial, even with Michael's reduced rate and partial contingency arrangement. But the HOA ultimately paid most of my attorney fees as part of the settlement, recognizing that I had uncovered wrongdoing that benefited the entire community. Some neighbors also contributed voluntarily to help defray my costs, which I found deeply moving. The audit that revealed Patricia's embezzlement cost the HOA $8,000, but it was worth every penny. Without that comprehensive financial review, we might never have discovered the full extent of her theft. The audit also provided the documentation needed to successfully prosecute her and potentially recover some of the stolen funds. Judge Morrison's written opinion in our case was published and became required reading for HOA board members and managers throughout Arizona. The judge's clear articulation of the limits on HOA authority and the requirement to follow proper procedures provided a roadmap for other associations struggling with similar issues. Several other courts cited the opinion when dealing with HOA disputes, giving it influence beyond just our community. The prosecutor in Patricia's criminal case, Assistant County Attorney David Ramsey, told me after the sentencing that HOA embezzlement was more common than people realized, but often went unreported because residents did not know how to detect it or feared retaliation. He said our case would help encourage other victims to come forward and would send a strong deterrent message to HOA board members who might be tempted to abuse their positions. As I sit here now, more than 4 years after that initial fine notice arrived, I sometimes wonder what would have happened if I had just paid the $1,500 and moved on with my life. Patricia would still be in power, still stealing from the community, still bullying homeowners into compliance with invalid fines. The improper fine scheme would have continued, extracting money from people who could ill afford it. The embezzlement would have grown, perhaps eventually bankrupting the HOA entirely. Instead, because I refused to accept being treated unfairly and had the resources and determination to fight back, an entire community was freed from a corrupt leader. Dozens of people got their money back. Proper procedures were established. A criminal was brought to justice, and future residents would benefit from the reforms and culture change that resulted. That is not a bad legacy for a simple backyard pergola. The afternoon sun filters through the wooden slats of my pergola, creating patterns of light and shadow on the patio below. My grill is heating up for tonight's dinner. I have invited several neighbors over, including Gregory, Tom, Sarah, Robert, and Jennifer. We do this every few months now, a casual gathering of people who went through something difficult together and came out the other side. Later, as we sit around the patio table sharing food and conversation, someone will inevitably bring up the Patricia saga. We will laugh about some of the more absurd moments, shake our heads at her audacity, and marvel at how everything unfolded. But mostly, we will appreciate that we live in a community where the rules apply equally to everyone, where leadership is accountable, and where standing up for what is right is supported rather than punished. That is what I fought for when I disputed that first fine. That is what the court vindicated when it invalidated 3 years of improper business by our HOA. And that is what makes this house, this neighborhood, this pergola, truly worth fighting for. The doorbell rings. My guests are starting to arrive. I get up from my chair under the pergola and head inside to greet them, grateful for the community we have built together and the lessons we learned along the way. Sometimes the smallest acts of resistance lead to the most profound changes. Sometimes refusing to accept injustice, even over something as simple as a backyard structure, can expose corruption and create lasting reform. As I open the door to welcome my friends, I think about how that certified letter 4 years ago set in motion a chain of events that transformed our entire community. It was not easy, it was not quick, but it was worth it, and I would do it all again in a heartbeat.